I see Mr. Campbell. Good morning, sir. Let me wait for Mr. DeRoche. Very good. All right, Mr. DeRoche, I see you here, sir. You've unmuted yourself. Excellent. You're ready to proceed with your argument. Go ahead, sir.
Good morning, Your Honor. Ladies and gentlemen of the court, opposing counsel. For the record, my name is Christopher DeRoche. I represent Mr. Noah Roy Wiggins, who is the appellant in this matter, and I would like to reserve 5 minutes for rebuttal.
Very good, sir.
And unless the court has any specific issues they wish for me to address instead, what I'd like to address is the issue of how the trial court essentially violated due process of law and essentially committed fundamental error when the Williams rule evidence in this particular case became an impermissible feature of this trial. It started in opening arguments when the appellee, the state, basically summed up to the jury, hey, we have a bunch of little girls here who need justice and we need your help. Didn't reference necessarily that there was one specific victim. They said there were these girls that were all molested by Mr. Wiggins, and not in the singular, plural, different people. And then it kept on going. Instead of just saying, we've seen records where Williams rule evidence was permissibly used in opening and closing statements, where they say, well, you're going to hear some evidence about how there's going to be some similar facts, and this person's going to testify that this happened to them. But remember, Miss Y is the victim here, and it's her case. But no, that didn't happen in opening and closing argument here. Instead, the state went on, sometimes for pages in the record, talking all about all the other people, except for actually our complaining witness.
Let me ask you a question, because having read the brief, that might have been an objectionable comment, but an objection was not made. So I assume that's why you're arguing fundamental error. You don't think it's necessary to preserve that? And you asked for a curative instruction. One may or may not have been given, but we'll never know, because it was waived, and maybe that was done for strategic purposes. Do you have any comment on that?
Well, as someone who's litigated child molesting cases, I don't think there's a strategic purpose for letting somebody rail on for 2 pages about how other people have gotten molested. So therefore, hey, he's done it once, he's done it 100 times, so why not find him guilty just on general principle because he's a bad person? He's obviously a pervert. That's really what this is all about.
But Mr., and I mispronounced your name. I always pronounce it the French way, but I guess you pronounce it DeRoche. I apologize. But Mr. DeRoche, this really didn't happen in this case. What happened in the opening statements, as well through the trial, is that they were making comments on what the evidence will show. And the Williams rule that the court ultimately allowed to come in went into detail about what is permissible under the law. So it's fair comment as to what the evidence will show. Can you agree with me on that?
Well, I would agree with you to a certain point. Now, when the government, the state, starts talking that there are plural victims, then they're going off of what the evidence is going to show. There's only one victim on trial in this case, not multiples. Only one. That's when they went off the reservation. They also started going off the reservation in total. And that's really that's really the heart of the argument here. The appellee spent a lot of time in their brief going over each and every item, going, well, this was acceptable in fair comment. This was acceptable in fair comment, and gave us a 31-page brief, which ought to tell us there was a lot of stuff here.
And the main reason that's the case, Mr. DeRoche, is the fact of the matter is we've written opinions that have allowed, several or voluminous Williams rule type of evidence. And that's not really the criteria. The criteria is that evidence relevant in order to show like corroboration that this was not simply, a mistake. And so in this case, I think what we just need to make a determination based on your argument, was the Williams rule evidence properly admitted by the court? And if so, whether or not it was made a feature of the trial by the state. And this is something for us to balance given the circumstances of this. So let's just take each one at a time. With respect to the Williams rules evidence coming in, are you disputing any of those issues with respect to the court's ruling, allowing those specific instances to come in?
As far as the individual items as they go, probably not. The difficulty comes in that not only it was really what they used it for in both opening and close. And it, especially during closing argument, this turned into less of a closing argument about the actual complaining witness and more about what happened to these other folks. Now, I did bring up in specific, there was one particular person, I believe her name was BW, and that particular introduction of her evidence, I thought was actually, that was probably should not have been admitted, actually, because when you look at her facts and what was happening according to her in her situation, it was very...
But Mr. DeRocher, you're not challenging the trial court's findings that, as far as this collateral evidence, that there was clear and convincing evidence on this to be admitted, right?
Not in that
right.
respect.
Okay, so right, so wouldn't that apply then to your argument that you're trying to make now with respect to BW? I mean, aren't you trying to challenge the findings of the trial court and allowing that? And if that's not being challenged, why should we be discussing that now?
Well, I was bringing it up in the context that her particular fact pattern even had less of a match than everybody else's fact pattern. And one of the factors that we look at in determining whether the admission of Williams rule evidence in its constellation constitutes an impermissible feature of the trial is how well do the facts actually relate to the actual offense. And while it may technically be admissible individually in its constellation, it can constitute a due process violation if you start looking at it and going, golly gee, this is really too far away from what the government or the state is actually arguing in this particular case. It's also interesting to note that really in closing argument, when you look at defense counsel and how they approached closing argument, they didn't necessarily hardcore argue she's lying or she's, there's a conspiracy involved. It was basically just sort of a kind of a vanilla closing argument when you really get down to it. So one wonders how much Williams rule evidence one really needed in this particular case. And then you also have to merge into the fact that ultimately we wound up with a mixed bag verdict. So the jury wasn't following lockstep with everything that the state had to sell. And when we've got that situation, we have to be especially careful with what the state introduced as evidence, because if they did wind up introducing, basically started to make this a feature of the trial, that could have very well influenced the jury. This was not one of these situations where the jury was obviously buying absolutely everything this complaining witness had to sell. They weren't. He got found guilty on some things and not others. So they were obviously thinking, well, she's correct on some things, but not others.
Can I just interrupt you? Because a lot of that is speculation on your part, honestly. But you started out your argument by saying you wanted to argue about due process and fundamental error.
Yes.
reading your issue on appeal, your issue on appeal seems to be limited to Williams rule motion being granted over defense objection, and it became a feature of the trial. So aren't you now pivoting this into a 3850 argument rather than the issue on appeal? It's the judge screwed up the McLean hearing, didn't weigh the evidence properly. I mean, I'm just confused where you're going with the argument versus what we actually have in the brief.
Okay. And I think that's because sometimes when we do Williams rule evaluations, the admission of it, especially when you have to have a Williams rule hearing like this under McLean, oftentimes when you admit this type of evidence, you can expect that there's going to be a due process violation if you start admitting the type of evidence that the trial court judge admitted in this particular case.
All right. Well, let's assume this argument is preserved and proper for this appeal, but you have an abuse of discretion standard. So in order to rein in a trial judge exercising discretion against your view of the evidence, normally there'd be a motion in limine to say, hey, you're going to let it in, be specific. And if they violate the motion in limine, you got an ironclad objection that has to be sustained. We didn't have that here.
Unfortunately,
was there a motion in limine filed below?
I do not believe there was.
Okay.
You are correct.
I'm just saying that there's a lot of problems that you're doing a great job at trying to cure and get around, but I'm not convinced that you are legally able to get around some of these problems.
Well, and as you pointed out.
Well, I used to be a trial judge. You're talking about doing a lot of trial work, and we all of us were trial judges, and we are always saddened when, if you lose an appeal for a valid issue that wasn't preserved, that's really bad. But if you just lose an appeal because it's abuse of discretion, that's something that you really can't control. The trial judge could have gone one way, could have gone another way, and given the choice, judges want a certain way, and you're kind of stuck with that. And you can't do a 3850 inside of this appeal and argue fundamental error in my view of this case, because it's not really before us. But you can keep going. I didn't want to interrupt you. I just want to give you the benefit of my logic.
Oh, but and I appreciate the input, actually. I really do. However, I think in my brief, I think I made both arguments, actually. But like I said in my beginning, I wanted to concentrate on one particular matter, even though I did argue in my briefs, perhaps two. But I did want.
You're not conceding the abuse of discretion argument in favor of the fundamental error argument.
No, I'm not.
Okay, I got you.
But I wanted to focus on the second one because I kind of thought I had addressed the abuse of discretion issue thoroughly in the brief.
I got you.
All right. And I thank you for pointing that out, because I did want to clarify that, and I appreciate that. But in essence, that's basically the heart and soul of the argument here today. As I said before, I believe the brief basically points out how the trial court judge abused its discretion on doing the McLean findings, and also I believe in its constellation, this also constitutes fundamental error. So with that, I would defer to the appellee.
Okay. And Mr. DeRocha, you do have your full 5 minutes for rebuttal. So I'm going to ask you at this time if you could just mute your microphone. And Mr. Campbell, if you're ready to unmute yours, we're ready for your response.
Lower left of your screen.
Okay, got it. Good morning, Your Honors. Thank you. David Campbell, representing the state of Florida. I'd just like to start off with, I guess, the abuse of discretion argument just briefly. There was a good case that was mentioned by counsel in his brief, Condi v. State from the Florida Supreme Court, and that would go to the amount of Williams rule evidence that was admitted. And in this case, I don't think we got anywhere near to what the Florida Supreme Court has, found to be acceptable. In that case, it was for the strangulation and murder of a prostitute, and the state had gotten in the evidence of the deaths of 5 other victims, also, that were strangled and their bodies dumped at the side of the road. And in that case,
And actually, Mr. Campbell, I think that case stands for the proposition, and I alluded that earlier. It's not solely the quantity, but also the quality and nature of the collateral crime evidence in relation to the issues to be proven that determine whether its admission has, and I think the words that they've used, transcended the bounds of relevancy to the charge being tried. And so our court has repeatedly also affirmed, the admission of extensive collateral crime evidence where the evidence was wholly probative of the material issues. And I think, Mr. Dorshia, when he mentioned that case, Condi really, what the Supreme Court basically indicated, that's what we need to focus on. So I just wanted to clarify that.
Yes, and that was actually going to be the quote I was going to bring out from them, that they repeatedly affirmed these cases where the collateral crimes evidence was wholly probative. And looking at the summary, as the judge in this case had explained when she was making a ruling that it was admissible, all of the acts committed against the other three child victims were directly probative of what happened to the victim, the actual victim, AM in this case, whether it was, digital fingering or penetration, oral sex, penile penetration. All of these acts that the Williams rule witnesses were testifying to were committed upon AM. So I think every one of those went to corroborate a different act that was committed upon AM. I didn't see anything in there that was extraneous. In particular, counsel was referring to BW, and he mentioned about where the digital penetration took place in a chair. I would point out that that was also in the same trailer where the other victims were. And then another time he had taken BW into the same bedroom where AW also slept, and that's where penile penetration occurred. So also I'd point out the relaxed standard of Williams rule evidence in child sexual battery cases. And it turns on whether it's relevant, to prove a material fact. It doesn't have to be exactly identical, even though I do believe in this case, they were very, close. They were sufficiently close.
I have a question for you.
Yes.
Your opposing counsel spent more time and began with the fundamental error argument. What's your position in response to that?
I believe that is talking about the Williams rule evidence and the opening and closing. That's the only argument he can make, because none of them were objected to, so it has to be fundamental error. If you're referring to actually introducing the Williams rule evidence, I think that was abuse of discretion, but I don't think there was fundamental error there when you look at the exact similarity of the acts committed upon the different children.
So I do think probably has arguments. I mean, you have no problem with intertwining the arguments. Normally they're separate things argued separately and maybe a different context, but you don't have any problem with him intertwining the arguments. You think that really that's appropriate?
I wouldn't say it was necessarily appropriate, but I do think they are intertwined. I just think that the first argument actually, I don't think he can show fundamental error there or abuse of discretion. I do think they are intertwined, but as I said, since most of my brief was responding to the second one, the arguments for the opening and closing statements, it had to be fundamental. So that's what I concentrated on. I think that's what he was mainly arguing.
Fair enough.
But I don't have a problem with it there, no, because I said I don't think it's actually an issue. I don't see how the judge could have abused her discretion considering, the standard in child sexual battery cases and the similarity of the acts. And I don't think there's a problem with the amount of the Williams rule witnesses, because Condi and also the case of Warnos both had 5 and 6 murders that were testified to. In fact, Condi even talks about there being 3 whole days of evidence just on the Williams rule witnesses, and that was not too much. If there are no other questions on that, I just briefly move on to the opening and closing. I did go through them, and what I found was in the opening statement, I believe the first 10 pages of it, the Williamsville witnesses were not even mentioned at all. It was just discussing AM and what had happened to her. It was the last three where the prosecutor starts mentioning that these other witnesses will corroborate the different individual acts. In the closing arguments, there were the prosecutor had broken it up into proving each of the 7 crimes that he was charged with. So yes, it's going to be mentioned, you know, the different witnesses will be brought up 7 different times. And in several cases, more than one of the Williamsville witnesses had one of these acts, one of these, you know, similar acts committed upon them. But reading over it, every paragraph that I saw, the prosecutor was always talking about how it corroborated what AM said, The same things happened in the same, you know, trailer, happened in the same rooms, happened in his room, happened in the children's room. The prosecutor wasn't overly emphasizing anything that happened to any of these Williamsville witnesses without relating it directly to this corroborates what AM said. AM said this happened to her, you know, digital penetration, digital fingering, say ejaculating, and then the cleaning up with the towels that happened to several of them. It went to corroborate, you know, items like the towels were in place where they were, the sexual toys were in place exactly where AM said they were. The incidents happened, you know, in the same place. Both of the Williamsville witnesses were, consistent about, say, the towels and the toys occurring in one particular room. It was always related back to AM. I didn't see any places where the prosecutor was striking out on his own, attempting to prove a charge against one of the Williamsville witnesses. I just don't think the record bears out that argument. Does the court have any other questions?
Nope.
Okay, well, with that, I would agree to look at the Condi case, and I do believe in your CV case, just to briefly mention, because counsel mentioned that, once again, the acts in this were not, you know, far more severe than what happened to AM. They were all, I'd say, equivalent acts. It wasn't like they were talking about a more severe act. Regarding perhaps it being his daughter, I mentioned that. His daughter, I don't think the state was particularly trying to stress that. It just happened to, I think that was just in the course of the conversation. And one other thing that counsel did stress was mentioning the age of NM. There was, if you read through there, some talk about one of the drawings NM had made, and it was of the defendant's penis, but was missing the tip. And the state was explaining that that was because that was the view of the child. And, you know, that's what she saw from her view, and what she saw, the tip was obviously not visible because it was up against her. So I do believe that if there's any stressing of the age or mentioning it, it had to relate to why her testimony or her picture that she drew might not have been complete. I think that's what that was all about. So if there are no other questions, the state would ask you to affirm. Thank you.
Thank you, Mr. Campbell. I'm going to ask you to mute your microphone now. And Mr. DeRochi, you do have your rebuttal time, sir.
Yes, thank you. Unless the court has any specific questions of me, I have no specific rebuttal.
Well, I have one specific question. It dawned on me that your argument might be enhanced if you could point to something, some evidence, similar fact evidence introduced in trial that the judge didn't consider at the Williams Rule hearing.
That's an excellent question. And right off the top of my head, I cannot think of one.
Okay. That's kind of what I thought, but I wanted to see what you had to say.
Yeah, both the Williams Rule hearing and the trial were rather, the Williams Rule witnesses were both testified extensively in both hearings. And I cannot think off the top of my head a specific fact that was related at the trial that wasn't necessarily at least alluded to at the Williams Rule hearing. I really can't.
All right, fair enough. Thank you.
Thank you.
Thank you, Mr. DeRochi. Thank you both very much. So I'm going to ask you now to please